Other 19-year-olds who don't do this, they get to go to bed when they want, wake up when they want, eat what they want, work out when they want. You don't get to do those things anymore because you committed a felony offense. And if you continue to act like you've been acting and not follow the rules, however insignificant you think those rules are, you're going to end up right back in here and you're going to end up going to prison for up to 10 years. Do you understand? So your life, you have to make some mature decisions as a young person who's probably not ready to make those decisions. It's going to be a conscious effort and a decision on your part to either do it or not do it, right? What's going to happen if I follow this is you're going to go to ISF. ISF is a 90-day program that's intended to help you make better decisions. But let me tell you what can happen. Between now and the time that you go to ISF, you're going to be in jail. If I get an incident report, it's a violation of your probation. You could get revoked off your probation before you ever go to ISF. Do you understand? And it's happened. Ask them out there. I'm tired of you young people acting like you're acting at our jail. They're tired of it. These people are just going to do their jobs, trying to go home, go with their families, make a living, pay their bills, something that you hopefully will want to do at some point in your life. Instead, they got to go to jail and deal with this. The crap from you kids. But now you're an adult for these purposes. If you get to ISF and you don't make it through that program, or I get incident reports from ISF, they send me those, you're not going to get out. You're never going to see the light of day again. You're going to go to prison. It's that serious. Do you understand? Okay. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. Again, if you do everything you're supposed to, this is a great opportunity today. I don't want it to all be negative, because you have some very positive things. You don't have a felony conviction on your record. If you're a convicted felon, it changes your life in so many negative ways. You're not going to get certain jobs. If you want to go to trade schools or school or anything like that, or college, you're not going to be able to do certain things, live certain places, all of that. So you still have that opportunity. And if you get everything together and you follow the rules, at the end of your probation period, the case is dismissed. You will never have a felony conviction. This is the chance of your lifetime to change it and live like the rest of us live, okay? The other side, though, is if you violate any condition of probation, you'll be brought back into court. You'll be found guilty, so you would be a convicted felon, and then the punishment can be anywhere in that range from 2 years up to 10 years in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Again, I know there's other people out there, there's other young people that are acting up. It's going to be up to you to say, I'm not doing it. I don't want to go to prison. All right? All right, you can go back with the bailiff. Yes, ma'am. Hold on a second.
Before he goes, Judge, in light of the fact that you are giving him an opportunity after deferred on the felony, in reviewing of his incident reports from the PSI himself and his juvenile history, which is quite extensive.
Yes.
It is my intention to proceed, obviously, with a plea bargain offer on those misdemeanors, but I think it would be important, at least with several of them, to have those on his record so that if he is back, kind of know what we're going to do then.
So you won't be able to go to ISF until you take care of those misdemeanors. They'll bring you over on a jail day to get those taken care of. Ms. Molfino will talk to that prosecutor. If you enter pleas on those, great. If you decide to go to trial, then you'll just have to wait to go to ISF until those take care of with the trial, okay? Also, I do want to make sure a condition of your probation is that you are not allowed to be in the possession of a firearm of any type. That means in a vehicle with anybody with a firearm. That means at a house where there are firearms. You are not allowed to be anywhere where there's firearms. If you're living somewhere where there's firearms, you either cannot live there, or they have to have those out of the house or locked where you cannot have access to them. Do you understand?
Yes.
Okay, you go back with the bailiff. All right, you're Taylor Douglas.
Yes, ma'am.
And Mr. Douglas was previously in court, entered a plea of guilty to the third-degree felony offense of obstruction or retaliation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yeah,
Any additions or corrections?
no, yeah.
Only that court is inclined to follow judge and certainly concur with the answer.
In addition, I have received, and you guys should have been given copies of jail incident reports. Have you all reviewed those as well?
We have them.
I'm not, but I take your word for it.
Okay. You don't like to follow rules, do you?
I follow the rules.
You do? You've been following the rules since you've been in jail?
Kinda.
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 Okay. So, how have you not followed the rules?
I don't know, just whenever, I say like whenever I get disrespected or something like that,
Oh, so when they disrespect you,
I just,
why do you think you deserve their respect?
cause I don't do nothing to disrespect them.
You don't? You don't? Sitting on the countertops, not getting down. Looks like trying to smoke in the bathroom, working out when you're not supposed to be working out, lying about it, saying you're brushing your teeth, teasing and cutting up with and being disrespectful, talking about the officers, act like a little kid. Taking food when you're not supposed to. Calling them some lovely names. B word. Telling them they're white and ugly.
That's what they said, I said?
Mm-hmm.
I don't know. I don't remember.
You don't remember saying that? So here's the thing, how old are you?
19.
19. So you're now on a felony, or about to be, if I follow the agreement, which I don't have to do. You're about to be on a felony probation where you have to follow rules whether you like them or not because you've committed a felony offense. So you don't get to make all the decisions for yourself anymore, right?
Yes.
Step down. Michael Dyer, Mr. Rojas. Good morning. Are you Michael Dyer?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Dyer, in cause number 25, DCCR 1340, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from September 9th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Dyer is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand that?
Yeah.
And do you want to reject that offer and have your case set for trial?
Well, would you tell me that I have to sign it today because I was gonna get another lawyer.
So here's the thing. Today, I just need to know, there's a couple of things. We'll take them in order. First of all, I need to know if you want to enter a plea of guilty and take the 15 years, or if you want to plead not guilty and go to trial. Okay, so I'll do the rejection and we'll get your case set for trial, okay? Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial quicker. Is that okay with
Is
you?
it the same thing? I still gotta go to trial no matter?
Yeah. I mean, either you plead guilty and take the deal or you go to trial.
I guess I go to trial.
And are you okay if I appoint a new attorney today?
I guess I can go with this one.
You want to keep Mr. Rojas? All right, so Mr. Rojas will begin preparation for trial and we'll get it set for trial. You may go back with the bailiff. Sarah Jordan,
I don't know what to make her judge. She says she's gonna either hire Mr. Kimler or Mr. Smith with one more resetting.
okay, we'll just do a reset on Sarah Jordan's 2 cases then. And Gerodrick Randall, this is sentencing. I'm about to have to take a break.
We came for a sentencing before, you rejected that because it's some new cases. We have a new plea.
Oh, okay, got it. Okay, so
No, they're not new cases in this court, no, but he picked up some cases.
okay, so we already went through. All right, are you Gerodrick Randall?
He's not.
And so did I just reset it or did I?
Hi.
What?
So in August, Your Honor, he pled true, and I think at that time we were looking at ISF as our agreement. It was reset for an updated report. Then we discovered he had
Yeah.
two new misdemeanors that occurred in August. And so I
Right.
filed a first amended motion October 22nd.
Okay,
So
but we need to go through
We need to
that.
please to that, and then we have an agreement that the court's okay with.
Okay. All right. Will he waive the formal reading of the motion?
He will, Your Honor.
Mr. Randall, in clause number 24, DCCR 0543, I have a first amended motion to revoke your unadjudicated probation. And we're going to start kind of all over. I know we've gone through some of this, but we're going to get pleas of true or not true again on all of
And
them.
Your Honor, with your permission, we've agreed to plead to 1, 2, 3, and then the amended counts of 10 and 11, which cover the several new offenses on
Right.
misdemeanors, but
Thank you. So it shows you were placed on probation October 7th of 2024 for aggravated robbery, and that was a 5-year deferred probation. Is that correct? The state's elected to proceed on counts 1, 2, 3, 10, and 11. Count 1 alleges that you violated your probation by committing the new offense of unlawful carrying a weapon May 3rd of 2025. And is that true or not true?
True.
Count 2 alleges that you committed the new offense of evading arrest or detention May 3rd of 2025. And is that true or not true?
True.
Count 3 alleges that you possessed a drug, marijuana, May 3rd of 2025. And is that true or not true?
True.
Count 10 alleges that you committed the offense of unlawful carrying a weapon July 13th of 2025. And is that true or not true?
True.
And then count 11 alleges that you committed the offense of evading arrest or detention July 13th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have paperwork now, again, on the case here that has your signature on it that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
He's not.
Do you fully understand them?
He's not.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State Tender's number 1.
No objection.
It's admitted. Any evidence that Mr. Randall's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily. Find those counts true.
Be Mr. Smith.
This shows 25 for habitual,
Okay.
and so was there something different?
I think we
that-
went down to 20.
There was a
Let me just-
20-year offer that
Yeah.
was previously rejected to proceed on non-habitual, which
Okay,
is a trial.
Yeah.
So we'll proceed on habitual and 4A.
so I want to make sure you understand, Mr. Bell, that the offer that the state has given is to go on, I guess probably count 1 and 2 instead of all of the counts that would make it a habitual offender for a 20-year term in prison. You have every right, again, not to take that and go to trial in a couple of weeks, but I do want to make sure you understand that after today, I will not accept that plea agreement. If you're found guilty and if those prior convictions are true, it means that your habitual status and the minimum punishment would be 25 years. Do you understand? All right, and you want to go forward with trial? All right, we'll get the cases numbered after docket and let you guys know as soon as docket's over. You can go back with the bailiff. Bless you.
Objection.
Yes, sir. Mr. Burbank, on Brandon Bell?
We'll just have a second.
Sure.
I might, 2 of those after.
Okay, on Williams as well?
Yes, Your Honor.
Ms. Perazo, on Traven Alexander? Sure, yes, ma'am. Well, okay. Mr. Parker, are you ready on Jamarian Martin? It's a sentencing. Jamarian Martin. Okay.
The PSIs are like huge now. PSI? PSI.
See, I haven't seen this whole packet. I just saw this, I guess. Not that it matters. It's all that's what they need.
And they're all underlined now. I don't know if you've noticed that.
What do you mean?
Like every sentence is underlined. They would like that yesterday. I don't know if yours is, and I didn't.
Mine's not been like that at
Oh,
all.
two dozen?
Well, they emailed me last week and then they got hard copies. And so it's.
That's weird looking. I don't know why. Okay, are you Jamarian Martin? And Mr. Martin was previously in court in cause number 25 DCCR 0196, entered a plea of guilty to burglary of a building. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor.
Any additions or corrections?
No worries, yeah.
Only that the state would request $500 in restitution, Judge. I think my conversation with the PSI author in this case, Ms. Banks, was subsequent to her already sending it to the court, so we were able to determine it's $500 in restitution.
Okay.
And I would also ask if the court is inclined to follow it, that it be with a condition of ISF at the very least.
So that's, yes. So my biggest question is, with regard to ISF, it's either substance or cognitive. And so because there's some drug issues, but there's also, he's young. And so what I'm considering is ISF cognitive and then JCDI as when he gets out. Does that seem appropriate for what we've got here?
I think so, Judge.
I think so. He came to court and tested positive last time, but
Right.
it probably would better address both with both of those programs. And then we can always follow up the state.
Yeah. Well, or, yeah.
Let's not go that route.
Let's- Okay, Mr. Martin, what I'm going to do, how old are you? 19. So my goal here today, and everyone's goal, is for you to be able to be successful. And so what's going to happen is you're going to be given some tools up front, not necessarily meant to be punishment, but meant to give you everything you need to change your life and be successful and go through this probation. So what that means, though, is if I do all of this now and then you violate later, coming back in and asking for another chance is probably not going to go very well. You understand? So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. I am going to order $500 in restitution and that you follow all of the rules and conditions of probation. That's going to include entering and successfully completing the cognitive track of the ISF program, which is a 90-day program to help you make better decisions. And then when you get out, you're going to be ordered to enter and successfully complete the JCDI program, which is the Jefferson County Drug Intervention Program. That is an outpatient treatment program, but it's intensive and it's meant to help you get off all the drugs and things like that. So you're going to be able to be hopefully making better decisions, not using drug. And if you do all of that, this is an excellent opportunity because you're not a convicted felon. You don't have this felony conviction on your record. And if you successfully complete the probation, you will never have a felony conviction. The case will be dismissed at the end if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, convicted of the offense, which means you would be a convicted felon and sent to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. Sorry. Jesse Griffin, Mr. Parker?
Your Honor, before you get him out, I was going to ask for a reset on that. I've talked to him. He has a new offer. He wanted to tell me some things and want to go more with me. He's a homeless guy that he just asked if I could give him more time. I think it might benefit moving the case.
All right, any issues? No. All right, we'll just do a normal reset on, let's see. Jesse Griffin. We're going to reset. Cecilia Delaney, that's a competency. Cecilia Delaney.
She's not,
Oh, is she not?
She should be.
Oh, she should? Oh, okay.
It's more, we meant to.
Okay. Well, I didn't think they had her. She I just assumed she wasn't, but she said she was here.
Okay.
She's in her.
She is here. Yeah.
She's in our jail. So I'll hold, if you can see, we've got to get that competency thing done. Yes, ma'am.
Huh?
You don't know that one?
What?
She's not here.
She's not here.
They're gonna work on getting her.
Thank you, ma'am. And so let's see, Khalil Harris.
Rejection, Judge. He's right here.
Khalil Harris. I don't see anything on here. Okay. Good morning. Are you Khalil Bradley Harris? And let's see. It says it's locked. There it goes. Never mind. All right, sir. In cause number 25, DCCR 1334, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from August 10th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? Yes, ma'am. And I'm assuming we've got the prior offense. So with regard to enhancements for trial purposes.
They haven't enhanced it, but they could.
So
That's been a discussion.
y'all have talked about this. So is there just the one prior felony?
Yes.
And is it a regular felony or?
Yes, it's a regular felony.
So I want to make sure you understand, if you go to trial and you're found guilty, that because you have a prior felony conviction, it would enhance your punishment to that of a second degree felony, which means between 2 years and up to 20 years. Do you understand? And I have a plea bargain rejection here on the tablet that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a cap of 5 years, which means you would leave your punishment up to me. I couldn't give you more than 5 years. I could give you 5, I could give you less. It would depend on the information that was brought to me at a hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
I do also want to make sure you understand that after today, unless there's some new information that comes to light that your attorney or the state's attorney does not know, I will not accept this plea agreement after today. Do you understand? Okay, so we'll get it set for trial. Mr. Harris, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney to begin preparation for trial a little quicker. Is that okay with you?
So you,
Well, it's up to you.
you can do one or we're gonna know.
Okay, well, Mr. Parker will remain on and begin preparation for trial then. All right, you can go back with the bailiff. Corey Balsamo,
Balsamo,
Corey Baltimore.
Mr. Paperwork.
should be,
Yeah.
oh.
Good morning. We're going to have to get them printed first real quick.
Right, it's like, what?
No,
That wasn't hard. Two years, let's take it.
Who's Erica here on? Erica Bursch. Okay. Are y'all ready on it? Okay. All right, sir, you are Corey Balsamo, or Balsamo. Will your client waive the formal reading of the motion?
So you're,
In cause number 20-34743, I have a motion to revoke your community supervision. Shows that you were placed on probation November 29th of 2021 for the offense of theft of service, a state jail felony. And that must have been enhanced because it was a 10-year sentence that was probated for 10 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to avoid places or persons of disreputable or harmful character, and that you were admitted using methamphetamines within the Abundance Living Facility with another resident. And is that true or not true? True or not true? True. Count 2 alleges that you provided a urine sample August 18th of 2025 that tested positive for methamphetamine. And is that true or not true?
Your Honor, state would waive counts 3 and 4.
All right, did you enter your pleas of true to counts 1 and...
There's 5.
Oh, I'm sorry, I didn't see.
We're waiving 3 and 4.
Gotcha.
Not 5.
Thank you. Count 5 alleges that you failed to successfully complete the SafeP program. Is that true or not true? True. All right. Did you enter your pleas of true to counts 1, 2, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
I see the problem.
Okay. It's a 10 over
10 over
10.
10, and it's,
He was enhanced, and it was already convicted, so we can't do state jail.
I missed that, Judge. That's my mistake.
So I have to delete this paperwork because it would have to be TDC.
2 years TDC.
Y'all go, and the paperwork's gone, we'll go back through this in a minute, all right. Let's see, Mr. Lewis, on Christian Montoya Lazo.
Yes, ma'am.
Ms. Burge? Good morning, ma'am. If you'll please raise your right hand, do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God? Yes, sir. Thank you.
It's court. It's like an August case.
Okay.
And that's what he's being held on here, is Harris County.
Yeah, he has a whole.
burglary. And an ice detainer.
Good morning. Are you Christian Lazo? Yes. And Mr. Lazo, in cause number 25, DCCR 1423, you're charged with aggravated robbery from May 25th of 2025. And Mr. Lewis, what is the announcement?
Judge, I've talked to Mr. Lazo briefly about the case, but there are some other issues he has out of county that he has.
To visit with the Harris County Attorney and Mr. Nichols, and then go out and visit with Mr. Lazo. And we'll see if we can get an announcement at the next court date.
Sure, Judge.
Thank you, Your Honor.
Thank you, Ms. Bursch. Denzel Spikes, Mr. Lewis.
Judge, hold on, I know Mr. Hopper was looking at that one.
Okay, I'll hold it. Robert Eaglin, it's
Yes,
a
ma'am, Judge.
bond hearing.
Robert Eaglin?
All right, sir, you are Robert Eaglin? Yes. And give me just a second. Mr. Eaglin is charged with aggravated assault on a family member with a deadly weapon, and Mr. Lewis has filed a motion asking that his bond be reduced. The bond is currently, let's see,
It was 150.
what is it set at now? Do y'all know?
I think 150.
150. And it looks like there was we were set for trial, and there was the state requested a continuance, and so Mr. Lewis has filed this motion to reduce bond. Ms. Malfino, what is the state's position?
Yes, Judge, the state did file a formal written motion to bring it before the court. I certainly understand that Mr. Eaglin, via Mr. Lewis, certainly entitled to ask for bond reduction based upon that announcement. Where I am is that the complainant in this case, if the court will recall, it was originally handled in CDC. She was unable to be located. So although the often stated in the indictment looks old, he has not been in custody for that length of time. So I'd like you to take that into consideration. She has recently had a stroke. She is still in recovery for that medical condition. I spoke with her on the phone. She's always been very attentive in reaching out to us. It's difficult. Her mobility is severely limited. Her speech is still limited based on that stroke. And for that reason, I would ask the court to consider allowing for continuance off of that December 8th docket, and so that we could know in advance so she doesn't have to leave her rehab facility. And I've discussed that with Mr. Lewis, who's always been very courteous about it. I understand the necessity for him to ask for a bond.
Sure. Mr. Lewis?
And Judge, that parcel is cut That involves, of course, the length of time that he did sit in custody while he was when this case was pending over in CDC. I think it was a very lengthy time, almost 3 years is what he was in custody for before that case was dismissed, because they could not locate her. Shortly after that, of course, it was refiled. He's been in custody all of this time. We were ready to go to trial because the stroke happened right before the last trial set. And I think, we discussed it at that point, which I was gonna, and this was the first update we've gotten that she's still dealing with the rehab and everything.
Okay. So,
And typically, Judge would know not to ask more than once. It's just a very severe medical condition.
sure,
And
yeah,
very
no, I'm
serious
going to grant the
aggravating
motion for continuance, but in turn, I think I'm required under
Yes.
17151 to do something with regard to the bond. So I want to get some specific information from you, Mr. Eaglin, so that I know conditions to place on that bond. Where will you live if you make bond?
My mother, with my mother,
What is her name?
Marvel,
Marva
Eaglin,
Eaglin, okay, and what is that address?
3705 East Lucas Drive.
'Cause that's here in Beaumont,
Yes.
okay. As far as you know, Ms. Molfino, obviously there will be some restrictions and no contacts. Was there any issue that you know of when Mr. Eaglin was out from the time that case was dismissed until the case was refiled with any type of contact or threats or communication with the complaining witness?
Not that I'm personally aware of, Judge. I certainly would be happy to talk to Mr. Laird about it. I know that the complainant at the present time is very concerned for her safety, just based upon the aggravated nature of the offense, and I don't feel like it's necessary to show the court the pictures of that, but I think you would probably.
I'm looking at the
agree.
probable cause, so it's an allegation of being stabbed multiple times?
Her throat was slit, yeah.
Okay.
Again, I certainly understand the bond requirement and would ask that in the event he does postpone, that he have to wear a GPS at all times so that we can monitor his whereabouts. I know the complainant's whereabouts. I would like him not to know that. And also for him to remain in Jefferson County, specifically in Belmont. He also has a prior felony conviction.
I'm sorry?
He also has a prior felony conviction.
Okay. All right, so here's what I'm going to do, based on the, my granting that motion for continuance. I am going to grant the motion under 17.151 to reduce the bond as well in Mr. Eaglin's case. I'm going to reduce your bond to $25,000 in your case. There are going to be several conditions that are extremely important. The first is that you will be required to wear a GPS monitoring device at all times. You will be on house arrest except for employment with my permission. So if you have opportunities to get employment, you need to get with Mr. Lewis. He'll let me know. All it takes is an email and I can approve or not, things like that. Also, obviously you can come to court and you can visit with your attorney, medical doctors, things like that. But other than that, you are to be on house arrest at 3705 East Lucas here in Beaumont. You're not to leave Beaumont. You are going to be restricted to live and work in Beaumont, Texas. Do you understand those restrictions?
I can speak now. I'm trying to change venue, motion to change venue because this case is prejudiced and it's been dismissed and it's been brought up 20 days later while I was out there helping my dying mother. I didn't do it the first time.
Okay, so here's the thing. You got a lawyer, a motion to change. All right. You're not
I
going
wrote the state bar about it and I'm.
your motion to
trying
change.
get some-
All right, listen,
I'm
your
just
motion.
trying to get something
Listen,
done.
don't talk over me, okay? Because I can change my mind real quick on what I just
I'm
did.
not even trying to bond out, ma'am. I'm trying to get out of the county with this case so that this case can get.
That's denied. Your case is going to be here in this court with me, okay?
Yeah, I understand.
So,
But I don't need a bond though.
then I'm going to withdraw everything that I just said. I'm going to deny the motion for a bond reduction. And so what we'll do is just reset the case on the next available trial docket, and we'll move forward with trial. Go back with the bailiff.
And Judge, that's what I was going to say. I'll give evaluate it.
Okay.
Because at the last time I talked to him, we were fine.
Okay.
Then all of a sudden, he stopped wanting to visit with me.
Okay.
So-
Just send something over and we'll get it taken care of. I know. Okay. If you don't want to do it. I made all kinds of good notes here. Russell Bean, Mr. Lewis.
Yes, Madam Judge. And if we can hold on that, we have
Sure.
an agreement worked out.
Okay.
But he's going to need to go plea on the misdemeanor cases first.
Okay.
I was just waiting for Mr. Cole to get here. He's his attorney.
Gotcha. And then Dijon Banks.
Thanks. That one, I've talked to Ms. Mofino about. There's a lot of discovery on that one.
Okay.
And that we still need to.
So you need some more.
Yeah.
We're going to reset Dijon Banks and hold Russell Bean. It sounds like he might need to, at some point, go downstairs, go down the hall. I mean.
Thanks, Judge. At some point, I may ask the court for your assistance in procuring some school records of the young child in this
Okay.
case. There's some autism involved, and sometimes those are difficult to get out to the court order, but I'll be glad.
Okay, yeah, just let me know. I'll sign an order if you need it. Okay. Mr. Burbank, are you ready on Brandon Bell?
Brandon Bell?
I did.
Yeah. Okay. Is that okay if I just do it?
Yeah.
He's in a wheelchair. Hey,
Good morning.
good morning, you're right. I had 2 counts.
No, I think he's the only one. They're just confused on which one.
Good morning, Brian.
Good morning, sir. You're Brandon Bell?
Yes, ma'am.
And this is cause number 24, DCCR 1008. Mr. Bell was previously in court, entered pleas of true in a motion to revoke deferred probation, pled true to counts 2, 3, 4, 6, 7, 9, and 10. And there was not an agreement on probation for aggravated assault with a deadly weapon. And I've received that updated report. Has everyone had an opportunity to review that report?
Good time, Chad.
I have, Your Honor, in addition to some medical documentation that Mr. Burbank has provided.
Was that provided to me?
Not,
Okay. I'm sorry.
probably not.
Okay. What should it have?
Based on the updated report, when it goes into Spindletop and some other stuff, Judge.
Uh-huh. I don't know what you're talking about. Yeah, I mean,
These are medical records from Spindletop.
okay.
And there's also medical records of how he lost his leg recently from being run over by a dump truck while working,
Okay.
which I think are factors that need to be addressed.
Probably in addition, Judge, if I may, to the fact that you recall that complainant in the underlying case for which he is on probation. It looked like a stretch to even put him on the probation with his history, but she was very adamant about wanting probation or even non-prosecuting, and she came and testified before you the last time the motion was set so that you could advise them both with respect to the no contact order, which I don't think either one of them were following, but I don't have proof of that, but I know
Okay.
that's been a concern, but I had some difficulty with that portion of the case.
Okay.
And if the court would also remember, she was expecting another child, they are expecting another child. And
Okay.
she's
So
also,
what, go ahead and make argument and then I'll,
she's also controlling the checking account. He's getting settlements and he's providing the money to her for the children. They still have a house together. But he does have a place to stay, Judge, and that is his mom's, which I believe she can't go to. And my argument, Judge, is, if I may, is that he has mental health problems. He's had some problems in reference to possibly smoking marijuana, but I think it's contributed to things that he has gone through in life. As I said, had some medical in reference to an amputation. Of course, he's lost part of his right leg. That was due to a dump truck backing up over him while he was working. And then you couple that with mental health issues. He was reporting, my understanding was he kind of was talking out of his head, as also reported by his mom. That was also outlined in the updated PSI report. We're asking, Judge, that you continue him on probation. He does have obligations with his significant other in reference to the newborn and making sure that they're taken care of, which he does have the funds that he has to be able to give to her. But if there is some program that he can have that's outpatient to maybe give him some direction. One last time, he was put on probation in April of this year, Judge. We're now.
Today's courtroom proved that every case is different. Some defendants walked away with a second chance, while others were given a clear warning that their next mistake could cost them their freedom. Justice isn't just about punishment, it's about accountability, responsibility, and the choices people make after they leave the courtroom. Which decision surprised you the most? Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more real courtroom moments every week.